Hello and welcome to the Amicable Law Group's monthly webinar series. We will be starting in just a moment. Please note this is a one-way communication, so hopefully you can hear me. I will not be able to hear you, but feel free to message any question in the chat box or email them at the conclusion. Actually, you can email throughout to brad@micklinlawgroup.com. Please note, as I will also indicate at the end of this does not create an attorney-client relationship, but is for information purposes only. With that, let us begin. Hello and good afternoon to those who might not have dealt with me in the past. My name is Brad Micklin. I'm the attorney and managing member of the Micklin Law Group, a law firm concentrated in empowering men and fathers in divorce, custody, and family law matters, with offices in Nutley, Montclair, and Saddlebrook, New Jersey. This is me. If you haven't dealt with me, also attached to this screen is a QR code, which should allow you to access my online calendar. If you are seeking a consultation, once you are scheduled to be contacted with my office to complete an intake, please note the meeting is not confirmed until the intake is completed, but you will be on my schedule and ready to meet. Let me just take a moment to show some of the accolades I've been privileged to receive, both from colleagues and from clients, as well as independent organizations. I post them not to impress you, but to impress upon you the wealth of experience that I hope to bring to this webinar, as well as to the work I do and the clients that I represent. Also been honored to serve as a national legal consultant. I've appeared on Fox News, Inside Edition, Larry King, I-24 News, and various other national media outlets. Again, just so that you can understand the experience that I bring to the information I'm providing you. Today's webinar, 6 tips for an amicable divorce settlement in New Jersey. Navigating the complexities of divorce can be challenging, but with the right approach, it's possible to reach an amicable settlement. Here are 6 tips to help you process more smoothly and a more collaborative divorce in the state of New Jersey. And if you stay till the end, I will provide you not 6, but 7 bonus tips. And trust me, the last one is the most important. You will want to wait for it. Without further ado, let's jump into tip number 1. Communication is the key as to all negotiations, but especially in something like a divorce. First, active listening, which you may have come across in other schooling issues, other modes of communication, but active listening is actively listen to your spouse's concern and perspectives to build a mutual understanding. Others will tell you it is about feeding back what they tell you in a way that shows that you heard and understand it and processed it. While that is helpful, what you really want to do is pay attention to what they're asking for. Try to understand why it is that they're asking for it. Quite often, settlement proposals can seem one-sided or beneficial, but if you take a moment to understand the other person's positions, concerns, and fears, it may help you to understand the terms that they're proposing. Second along this, respectful dialogue. Please always maintain respectful and constructive dialogue, even when discussing something that's difficult or emotions intervene. That is very challenging. I've had clients who come in amicable, but are well ready to make it adversarial or acrimonious. I even had one client bring in a photo album so that when discussions fell through, you can pull out the photo album and point to dates and pictures and memories. Approaches like that don't help. They may help you in the moment, and you may feel good doing it. But trust me, long term, it's going to be detrimental to the discussions and ultimately to your overall positions. So lastly, along those lines, always maintain your composure. Emotions can run high in divorce discussions. Remember, there's strength in maintaining your composure throughout the process. Again, the process often is ongoing. It is long and it will sometimes span many different hearings. You need to maintain your composure so that you will actually benefit you, and if you have children, your children and family. 2, understanding your financial situation. Gather information, analyze implications, and seek expert advice. Thoroughly review your documents, your assets, your debts, and your income, and your expenses so that you have a clear picture of your financial standing. And you may actually want to write them down or make sure that you have them easily accessible. You want to understand the potential financial implications of different settlement options so that you can make informed decisions. And ultimately, and most importantly, you want to consult with a financial advisor or an accountant to ensure you're making the best choices for your situation. There are a lot of financial considerations you need to consider and obtain advice. It's not just about the dollars and cents that you have or that you're dividing, but it can often be the tax consequences, both now and in the future. For instance, you're going to be dividing assets. Some have short and long-term capital gain issues. Some have income tax issues, and others don't have any tax issues. You need to know which ones do and don't have these issues. You need to look at your long-term planning. You need to look at what may happen to these assets long-term, how you're planning to use them, whether they are retirement-based or not, whether or not they are easily liquidated into another asset or cash in case you need it. You may also want to look to your future changes of circumstances as you age, as you seek to retire, as your children enter or exit college. These things should be considered when you're analyzing your financial situation, and these are the reasons why you should seek expert financial advice prior to and throughout your settlement discussions. Number 3, consider mediation or collaboration. 1, mediation, which is a neutral third-party mediator which can help facilitate constructive discussions and guide you towards an agreement. Collaboration is a divorce process that allows you and your spouse to work together with legal counsel to reach a settlement. And 3, these are all intended to avoid litigation. Pursuing any collaborative or mediation approach can often lead to a more amicable and cost-effective resolution. What is also not mentioned here, which is another option that's favorable in many acrimonious divorces, which is why it's not here, because this is intended to help you resolve it without the acrimony, but arbitration can often be a very constructive alternate dispute resolution process in addition to mediation or collaboration. All 3, mediation, collaboration, and arbitration, are very intricate and could and do have YouTube videos that I've covered specifically on all of these issues. You can go to my YouTube page at Brad Michael Micklin and just run a word search on my page, and you will get videos on there. I do have very concrete, specific opinions on all 3 processes, the good and the bad, as well as how and when to use them. So I will not belabor the points in this video because it will be too time consuming, but they all can be used effectively. They all should be considered if you are not able to settle your divorce amongst yourselves and early into your litigation. If you don't mind, take a minute, and if this video has been helpful, as well as any of my other videos, please like and subscribe to the videos. They will help you get notifications when I post other videos. They will also help circulate these so that more people can benefit from this information. Feel free to leave a comment. I do review my comments every 3 or 4 days. I do my best to respond to anything that is meaningful and warrants a good response. So again, if you could just take a minute and like and share this, subscribe, and then we will move on to our next 4th tip. Tip number 4, prioritize the best interests of your children. Custody and visitation, which I should have changed probably to parenting time. As an aside, New Jersey does not call it visitation any longer because you don't visit with your children. It's parenting time because you are the parent You make the relevant decisions. Again, I have videos that will describe this on my YouTube page, as well as my website, micklinlawgroup.com. It's MICKLINLAWGRUP.com. Now, returning to number 4. Under New Jersey law, child custody and visitation arrangements must be with the child's best interest as the top priority. Courts will consider factors like the parent's ability to communicate, children's relationship with each parent, and the children's needs. In actuality, there are 14 different criteria. They will look at siblings relationships, domestic violence, work responsibilities, educational needs, and many others. But ultimately, just remember that the best interest of your children, of your child or your children, are paramount. And I stress that before moving on to the other tiles here, because many people think best interest means what helps the parent. And this will often be grounds for seeking custody, that they have babysitters, they have family support, they can earn more money if they have less time or more time, or get to relocate. While that may be helpful to the parent, doesn't necessarily mean it's best for the children. So always remember that that's where the focus must be. Second, financial support. New Jersey has specific child support guidelines to ensure your children's financial needs are met. Alimony may also be awarded based on factors like the length of the marriage, the relative incomes of the spouses. Courts will also consider a number of different factors, such as the length of your marriage and the lifestyle. The lifestyle and the equitable distribution, and about 11 other factors that I, again, will not go into at length. And lastly, co-parenting. New Jersey courts strongly encourage parents to maintain a cooperative co-parenting relationship, as this is shown to be in the best interest of children and their well-being after a divorce. What that means is the current philosophy in New Jersey family courts is that all children benefit from having both parents in their lives as much as possible. There is technically and currently a presumption that both parents should have much time with their children as possible. No one parent is favored, although, quite honestly, I still believe there's a gender bias towards women, which is why my practice is concentrated in men's and fathers' rights. But again, a topic outside the scope of this settlement webinar. Before moving on, when it comes to custody and parenting time, things that you need to consider inside of all these arrangements will be things like changes in your future, both yours and your children. If you're going to be changing work, if you're going to be relocating, if you anticipate getting into an intimate relationship, and whether or not that relationship may have other children involved. On a more short-term basis, you might want to look to the holidays you celebrate and whether or not they're the same as the other parent. Deviations from financial support like child support is possible. You may want to consider whether or not there's a reason to vary the child support guidelines, either up or down. There might be special needs that your children have, special talents, extracurricular activities, daycare. These things may be temporary or ongoing. They may be extraordinary or not, but you could consider whether or not these get included or excluded from financial support. And lastly, around co-parenting, some things that have been topics of controversy recently between a lot of my clients is the introduction of new partners. You may want to consider whether or not that should be addressed. Are there going to be guidelines as to when and how a partner could be introduced? Is there maybe an age at which children should or should not be introduced to partners? You have concerns if they're going to be calling the other parent mom and dad. You may want to address this early into a settlement discussion so that co-parenting arrangements are clear and understood as you go forward. Number 5, be willing to compromise. Probably the most challenging of all processes or points inside of a divorce or family law settlement. 1, flexibility. Approach the settlement process with an open and flexible mindset. Be willing to find mutually acceptable solutions. Balance Recognize that an amicable divorce requires both parties to make reasonable compromise and negotiation. Engage in constructive negotiations to ensure a fair and equitable distribution of assets and responsibilities. Now, while these tiles are all helpful and I certainly recommend them, there are certain aspects of negotiation that are a little more practical that I think you should also keep in mind. First, for good or bad, I usually analogize the divorce mediation and settlement process like buying a car. One party's coming in high, one party's going to come in low. The mediator or arbitrator, or not arbitrator, I guess mediator will indicate you should split the difference. So if you unfortunately have come in at a reasonable position, what you think is accurate and fair, but somebody has come in at an unreasonable position, the third party is likely to tell you to compromise between the two, and you will end up giving or losing more than you reasonably anticipated and thought should be. Not that I'm encouraging bad faith negotiation, but in my experience, I don't find that a party can come into a settlement negotiation advancing his or her initial good faith final offer, because the numbers will only move. That's the purpose of negotiation and mediation. As I said in earlier slides, when it comes to compromise and considering the other person's position, that will only be if you are willing to move off of your position, and that should be contemplated before you set and advance that position. Additionally, I've learned that from a psychological standpoint, that people who compromise first will compromise the most and the most often. Now, I'm not saying this to discourage you from compromising, quite the opposite, but you should realize that once you do start to compromise, the mindset will allow you or force you to compromise more often. And I think the reason for that is you start to look at the smaller remaining portion and think that's all that you're discussing. So for instance, you're negotiating over $100 and you've offered 50 and the other person's offered 0, and somebody tells you to cut the difference. Well, you're thinking it's only 25, it's the difference between 0 and 50, but it's really 50 because it's the difference between 0 and 100. But because you've already moved off of your 100, sometimes you lose sight of that. And I'm not saying that that's a bad thing in all cases. That may help you get to the end of your settlement. It may help you move on with your life, and it may serve you and your family's best interest. My point is to know this going in so that you can adjust your approach and your discussions and still be amicable and still get a fair resolution for you and your family. Number 6, seek professional advice. Understand your rights. Consult with an experienced divorce attorney to ensure your rights and interests are protected. Navigate the process. Your lawyer can guide you through the complex legal procedures and requirements in New Jersey family law. Will help you avoid costly mistakes. Professional legal advice can help you avoid common pitfalls and reach a favorable settlement. And I don't say this because I am an attorney. When I got divorced, not only did I consult with attorneys, I had an attorney represent me. I believe that it is nearly impossible, or at least highly impractical, to believe you can maintain independence and objectivity, that you can review the options as well as the other person's positions. And lastly, most importantly, it's nearly impossible for a layman or woman, layperson, to understand the laws intricately enough to be able to make a decision without professional legal advice. Now, this doesn't mean that you need to hire a lawyer necessarily and go into a settlement discussion with a lawyer, but it means you should at least consult with a lawyer, with an attorney or a lawyer. That if you are going into mediation without counsel, that you have an attorney that you can consult either during the process or to review the agreement before you sign it, so that you can ensure that what you are doing is not just fair and equitable, but that it resolves your issues. Not knowing the law, not having advice, you may believe you're coming to a settlement and then find out that there are issues that haven't been resolved or that still remain, or that you resolved them in a way that is not feasible and in limited circumstances, not appropriate or lawful. Now, the latter or the last is rare, Courts will generally accept most terms that you agree upon if you both believe they're fair and reasonable, but there are circumstances, especially around child custody and child support, that can be deemed contrary to public policy and therefore unacceptable. And having professional advice, at least beforehand, will help you avoid those pitfalls. And for those that did stay as I requested, your additional bonus tip number 7, the most important point, is New Jersey laws that divorce agreements must be in writing. 1, a signed writing is required. New Jersey courts will only recognize divorce agreements that are memorized in a signed written agreement. Oral agreements or unwritten understandings are not sufficient. 2, this protects both parties. The requirement for signed writing helps ensure that both spouses fully understand and consent to the terms of the divorce and provide important legal protections. So 2 things, again, to remember, it's got to be reduced to writing and signed. And that's good and bad because you could spend all day, you could spend weeks negotiating a settlement, leave happy, having compromised, having spent a lot of time and money, and reach an agreement, all to find the very next day or next hour that the other person rejects it, revokes it, and if it wasn't signed, it doesn't matter. And this can be even a simple term sheet on a notepad that's initialed and signed, embodying the basic terms. But like I said in Title 2, this cuts both ways. You could spend all day or weeks and a lot of time and money negotiating a settlement and leave. And when your head is clear, you realize that you don't want the agreement. You too can revoke it by simply saying that you want to do so. So it's good and bad, and there's never clarity or simplicity as to determine when you should or should not revoke a settlement agreement. But realize and remember that you do not have one until it's reduced to writing and signed by both parties. So conclusion, for a smoother path forward, by following these 7 tips, you can negotiate the divorce process in New Jersey with greater cooperation and understanding, leading to a more amicable settlement and a smoother path forward for you and your family. If you're interested in contacting us, you can contact the Amicable Law Group and me, Brad Micklin, at our website, micklinlawgroup.com. You can call us at 973-562-0100. You can check out our YouTube page, as I mentioned before, Brad Michael Micklin. I have a Twitter and LinkedIn page, but honestly, I don't use it too often, but a lot of my information will be cross-published, so things that go onto my YouTube page will also be on my business Facebook page, Micklin Law Group, my Twitter, and my LinkedIn. And again, always on micklinlawgroup.com. Again, as I just mentioned, you can connect with us on social media and YouTube, all the pages that I mentioned. I have a business Facebook, Micklin Law Group, Brad Michael Micklin for YouTube. I think it's Brad Micklin for Twitter, and probably the same for LinkedIn. There's a link on the bottom for my YouTube channel. I don't think you can actually click on it. I don't think it's a hyperlink, so I apologize, but it should be easy to find me just by running my name search. And lastly, but most importantly, legal disclaimers. I won't read the whole slide to you. As I mentioned in the beginning, as tongue-tied as I was, this is advertising material. It is not legal advice. It does not create an attorney-client relationship. See, got it right that time. But I do certainly hope nonetheless that it helps you and your family.